Continuing on the subject of incoming mail when you're sitting there as an inmate, and this will be a little bit more expansive than just that, but among other things I got in there that was very valuable was a template that I designed for a bill of particulars. And I'm going to have that available as soon as I can get it up and on the YouTube website. And you want to send that in to your loved one who's in jail and have them file that with the DA or the solicitor or whomever they're called, because that forces them to identify the nature and cause of the accusation. That's another way to say jurisdiction and venue, which they can't do, because to do it, see, the only three jurisdictions we have, look at Article 3 of the Constitution of the United States: at law, equity, admiralty. Now, if you've done your legal research, and trust me, I have, you know that a court of equity doesn't have any criminal jurisdiction. That's purely civil. Admiralty and maritime was also known to the framers of the Constitution as a jurisdiction foreign to our Constitution and unacknowledged by our laws. Declaration of Independence. Can't be that. It could, in theory, be that in a federal court, but state courts are specifically forbidden from exercising admiralty pursuant to Article 3 and Section 9 of the Judiciary Act of 1789, 1 Statutes at Large 73. When you can talk to the judges in open court and say what I just said, you're going to get their attention. It scares the hell out of them because they don't know what to do, because if it's admiralty, they've got a real problem. They're sitting there without jurisdiction, and no jurisdiction equals no immunity. That's a little equation you're going to want to familiarize yourself with. If they don't have the one, they don't have the other. Now, if it's at law, common law, we find out, and my record has established, and you'll see documentary proof, there are no common law courts, except perhaps the Supreme Court of the United States, so it can't be common law. Where the hell are we, and where are you? My research has determined that you're in a federal territorial legislative tribunal, a subject matter for another day, but you can see immediately the problems, insuperable problems, that creates for the DA to have to admit that, because they're admitting we have no jurisdiction, and we're admitting that our state isn't a state. That's a hell of an admission and confession. It brings down the whole system. It gets even better with the BOP, because they have to identify each and every element of the crime that they have to prove in order to convict you. And the Supreme Court says, in a case called Re Winship, 397 U.S. 358, and we'll go over this case in great detail later, that they're required to do this. And if they don't do it, then the case gets thrown out of court, because you have no way to put on a defense if you don't know how to defend yourself. So these BOPs, my goodness, they're so powerful you can't, it's just amazing. And I have yet to lose a case when I put a BOP in, because they don't know what to do. So these kind of documents come in, and my friend sent me at least some of my jury instructions, and he sent to the prosecutor and the court the entirety of my jury instructions in digital form, and I had at the time 574 of those jury instructions, all relevant and admissible. And what happens is you go in and you have preliminary things before you go to jury trial, and you discuss, are these jury instructions going to be used, and if not, why not? And if the judge makes so much as a single error, that can be reversible error, and they know it, because they're keeping you from putting on a defense. And where I come from, the jury has the right to rule on the facts and the law. The Supreme Court says it. I believe it. Case is Brailsford v. Georgia, 2 Dallas 409, 1792. This is a hell of a problem that they have with this. So these BOPs, this may get you out of jail quicker than anything else, especially once we start sending people to jail because of it, because if they proceed without jurisdiction, then they're liable for all of it. That's where the power is put into our system. So that said, you get materials like this coming in, and then we had other materials that my friend sent on this DVD that had some videos of things that I was doing on Constitutional Crisis Channel. Then it just gets even worse for them, because what are they going to say? We never saw this stuff? Well, we don't know, but if they didn't, that means they didn't take the time to find out whether they had a case, whether they had jurisdiction, and that's going to beat them in a subsequent civil case if a case even needs to be filed. In my case, I don't think it'd be anywhere close because they've got no defense here. They're not going to get a motion to dismiss, and they're not going to be able to defend it in front of a jury. That's the kind of power that we have, that the framers of the Constitution gave us following the American Revolution, and it's about damn time we started to learn how to use it. They didn't teach me in school 50 years ago, and they're not teaching you now, and that's a deficiency I'm trying my best to correct. Thank you.